I think most people understood coming into this, and I suspect even the government understood coming into this, that this was probably going to be a bit of an uphill battle. So from that standpoint, I think there were parts of it that went about as expected. I think there were probably some parts of it that may have gone a little bit better than anticipated for the government. It certainly could have gone a lot worse. But I also think there were a lot of opportunities on the other side for justices to push back against the ACLU's position, where we didn't really see that in a way that I think many of us who were paying attention to maybe some of the amicus briefs might have anticipated based on arguments raised in those amicus briefs that could have been used to push back on the ACLU a little bit. So I think there's a bit of a mixed bag overall. One of the big things that we saw hesitation on, especially in the first set of questions directed at John Sauer for the government, were questions about applicability, right? Administrability. Basically, how would we do this? What does this look like? Essentially saying, well, is the government trying to take this bright line rule and put it onto something that isn't really as clear cut in terms of practice, in practical application, as the government may make it out to seem? There were certainly some questions, I believe, from Ketanji Brown Jackson about what does this look like, right? Questions that I think, from taking a step back, I'm not sure actually that important to the overall doctrinal questions of what does the 14th Amendment Citizenship Clause actually mean. But we did see a lot of those types of questions, and especially from some of the justices who I think, to the extent you might suppose some of them were disposed to be on the government side, you did see some pushback there. And so I say that's what stands out the most. And again, to some extent, to me, what stood out was the lack of pushback against the ACLU's position. Some of the things that I and others who think the government is correct on this might point out or frame as sort of the ACLU's presumptuous assertions about history, suggesting that, for example, the Civil Rights Act's language of being not subject to any foreign power. Well, we'll just sweep that under the rug and say, well, it's obvious that the only thing that meant was the common law exceptions. Well, that's what we're arguing about, right? That is literally what the argument is about. You need to do more than just assert, well, of course that's what they meant, because all of the briefing is about how actually, when you look at what they said, they meant something very distinct by that. And so it was a bit disappointing to not see that pushback from the justices. When you look at the cases that the arguments themselves focused on, certainly the 1898 case of Wong Kim Ark comes up quite a bit. So Wong Kim Ark, depending on who you're asking, means the government has to lose because the Supreme Court already decided this, or if you're the government, it means, well, no, that's actually perfectly consistent with our position. So Wong Kim Ark was a case that dealt with the U.S.-born child of Chinese individuals who were lawfully and permanently domiciled in the United States. So Wong Kim Ark was born in the United States. He lived his entire life in the United States. He was a lawful permanent resident. And the question was, is he a citizen, despite the fact that his parents, under the nation's naturalization laws, were not allowed, they were barred from themselves becoming naturalized citizens? What the court actually holds there is quite limited. And again, if you listen to oral argument, you heard some discussion about how much it means. That the holding itself was about the citizenship status of the U.S.-born child of someone who is lawfully and permanently domiciled in the United States. The government's position is that that's what it's limited to, right? That says nothing about people who are here unlawfully. It says nothing about people who are here on a temporary basis. And then you have the ACLU's position, which is much broader, which is, if you read some of the reasoning in that case about why the court came to that conclusion, that would seem to have the broader implications that should, in their mind, settle this case for these other categories as well. I was disappointed to not see a discussion of some of the other cases. Well, I guess they're not cases, but sort of legal precedent, if you will, in the sense of discussion of 19th century cases where the executive branch actually weighed in on citizenship status. This came up in many of the amicus briefs, parts where the executive branch said, no, this person's not a citizen, even though they were born in the United States. Again, I think that was one of the missed opportunities to really push back on the ACLU's position, and it just didn't come up in the same way that Wong Kim Ark did. The ACLU's argument is essentially no one up until Donald Trump ever thought that this was a viable way of framing birthright citizenship. And the reality is, when you look at decisions by other executive branches under other presidents during the 19th century, you actually did have executive branch decisions saying, no, we're not going to issue a passport to this person, even though they were born in the United States, because they weren't born subject to our jurisdiction, because their parents weren't lawfully or permanently present in the United States. And I think that's important. I understand that's not a Supreme Court decision, right, in the way that Wong Kim Ark is, but it is important when we're talking about, how did people at the time actually understand this language? And this would have been even before Wong Kim Ark. It would have been earlier and closer in time. So again, I think a lot of missed opportunities within questions by justices to really push back on some of that history. I've seen everything from people just assuming this is 9-0 against the government to this presumption that maybe it's sort of 3-3 with 3 toss-up justices, which I think may be a little bit optimistic. I do think there's a path forward. I think I wouldn't be shocked necessarily. I wouldn't know how to quantify it, but I wouldn't be shocked to see some sort of plurality opinions splitting the baby somewhere, whether it's between illegal immigrants versus temporary, people who are temporarily present in the United States. I also wouldn't be shocked, in the same manner to see. If you recall from the arguments, there's this discussion about, well, do we decide this based on the statute, regardless of what the language of the 14th Amendment means? Maybe they split the baby that way. I think in that case, that probably works against the government. I think at the end of the day, there are just so many options for what this could look like that I think even amongst people who want to make guesses, pessimistic about the government's odds here, I think it would be hard to pinpoint what exactly that set of coalitions looks like when this is all said and done.